Mr. Smith had sent his cousin to do DNA testing for him.
The father committed fraud or attempted to commit fraud upon the court.
The state is asking to make the temporary order the final order of the court. The court had given us time to amend our pleadings to include retroactive support, which I believe the state did. So at this time, we're asking that all of the temporary order amounts be finalized, and with the addition of appropriate guideline support, which the state is willing to give testimony on. And in the prior order, Mr. Glass was released as of the 31st day after the date of your signature on the order. Unfortunately, we're about 2 days shy of that, so Mr. Glass has been very patient.
Okay, I'm not finding the amended plea. Okay, let's see what y'all file those amendments before the temporary hearing last time.
No, Your Honor, I believe it was after.
Okay, they're not in the file. Okay, let's see if they didn't move them around on me somewhere. Let me make sure. Okay, that's the order for the second parentage testing.
And if Your Honor remembers this case, this is the case where Mr. Smith had sent his cousin to do DNA testing for him.
Okay, that's this one. Okay, all right, but I still got okay. Because yeah, I did the second. That's when I pointed the ad litem, and I did the second parentage testing and so forth and so on. We did that, but again, I'm not finding that second set of pleadings and service on dad. So I'm not sure if I can do retro without those being in there, please.
Your Honor, we have a file marked copy that says August 26th.
Oh, that's why 3 days ago. Okay, that's not in the file, and obviously he hadn't been served. So we're definitely looking at a reset until he gets served.
I apologize, Your Honor.
Okay, yeah, I can do our notices sent to last known address, so forth and so on. How you want to get it done? But yeah, that's obviously not going to be time enough, even under the 10-day rule, for me to do a final order on that issue. Everything else we probably could, but the issue of retroactive, mom wants back child support for the possibly since the date of the birth of the child. We got to dot our I's and cross our T's to get that done. And of course, by then, Mr. Glass will be free to go, and won't have to worry about it. Here's the deal, Ms. Constantine. Under Texas rules of civil procedure, which you don't, I know you could care less about, but as lawyers and judges, we have to. The states filed an amended petition to change this around so we can not only address the current child support and all that, but refile so we can ask for back child support covering the time since the child was born, since the child's been born less than 4 years ago. For that to be done, they filed it, but they have to actually notice and serve him on that. And the filing just took place less than 3 days ago. And so we're not in conformity with him being noticed and served. So until that conformity can be met, I cannot take that issue up. It's probably going to take at least another 30 to 35 days for us to do it. But in the interim, I'll keep the temporary order as is. And we'll come back on a date sometime, probably late September, well, probably in October to cover everything, to get that done, where we can see about ordering you being able to get back child support, since it looks like the child was born in December of 2021. So I'll look at ordering back child support starting the first day of January 2022, but only after we dotted our I's and crossed our T's. Otherwise, it's a void order, ma'am. I know that's a lot of legal mumbo jumbo to you at this point, ma'am, and I know the state probably hadn't had the opportunity to talk to you about this in a breakout room, but do you have any questions at this point, ma'am?
Just one. I just remembered. I spoke with my caseworker, and they were supposed to get back with me about me having to pay for that second DNA test. I was wondering, is that something that I speak with you guys about, or do I speak with them about?
Oh, okay. You're talking about your caseworker in your home state?
Yeah, she told me I was supposed to ask the first court date why I had to pay for the second one, and I had paid for the first one. She told me that was something that I was never supposed to pay for.
I don't think the state charged Mr. Constantine to do the DNA test. I don't see anything in the file that shows that. So,
Your Honor, that would not be routine procedure in this case, especially since it was not her fault. There was a second DNA test needed.
Yeah, I know.
So I would advise Ms. Constantine, ma'am, if you'll contact us. Unfortunately, I don't have access to that data, so I can't tell you whether or not there was a charge sent to your state or sent to you, but they'll be able to talk to you about it and maybe get you some kind of answer on whether or not we can reimburse you for your expenses, because it shouldn't have been, the first state is always on the state of Texas. We always pay for the first test.
Yeah, it was the second test that I had to pay for.
All right, and again, that's not your fault. In fact, I would make Dad responsible for paying for all of this because he tried to pull the look at me now, I'm not here.
Yeah.
I will make a note in your case, ma'am, so that it's very obvious that you shouldn't be charged for the second test. But if you'll just follow up with the calling on the main number and seeing about that.
Yes,
Okay.
ma'am.
And my sister reminded me at the time originally that we didn't know that Dad pulled the old hocus pocus on us. That he sent somebody in to substitute for himself, then that's why it came back negative. So obviously that may be the circumstance, but the state needs to let them know, hey, if this guy sent somebody in falsely to take the blood test for him, and it wasn't a legitimate test. Okay. And if you need that in the court order, Ms. Hubbard, please do so. All right.
Yes, Your Honor. I can make sure it's in the reset.
Okay, good enough. Yeah, ma'am. Well, she's gonna make sure that's in the reset order, and hopefully, I'm dealing with bureaucrats, so I never know what's going to happen because every bureaucrat has their own idea how they should be running how they should be running things. But you can show them, hey, this is the reason we had to do the new order. The judge made a finding that we had to do the new order because the father committed fraud or attempted to commit fraud upon the court. And that's why the second DNA test was ordered. So yeah, and you'll get a copy of that in the reset order, ma'am, to show anybody up there the circumstance. All right.
Okay.
All right. And if the state of Texas sent the bill, Ms. Hubbard, see it. Yeah, nip that one in the bud as soon as you can. All right. Thank you.
Yes, Your Honor.
All right. Anything else, Ms. Constantine?
That's it.
All right, Mr. Glass. Anything else on your behalf?
No, Your Honor.
All right. Thank you very much. Mr. Glass, how long you have that balloon flying behind your head? It's getting a little distracting, sir.
Oh, it'll be gone today. Today's her birthday. I bought it a couple days ago because I was trying to convince her I remembered her birthday before her mother did, so I'm the better person.
Okay, whose birthday is it today?
The 7-year-olds. Well, I guess the 8-year-olds now. I have to go buy an 8.
Well, today's girl number 3's birthday too, so happy birthday to both of them, okay?
Yes, sir.
All right then. And one of my best friends, his birthday too. God, I hate August. I think this is about the 20th one this month so far. So yeah, we're good. Anyway, I'll thank you very much, ma'am, and we'll see you back in October when we get the new service and the state can confirm that they sent the modified or the First Amendment petition to his last known address in conformity with the Texas Rules of Civil Procedure. All right.
Yes, sir.
All right, thank you. And that's where I'm going to write that up, mumbo jumbo up in the file, and I will see you then. Thank you. We're off the record.
Okay.